Bob, I believe you are now live.
Terrific.
Before you begin, I have a Mike Keenan here as well. I don't know if you need him as well. Or
He's working with you?
I don't know who this is.
Mike is one of the
applicant. He's the
Yeah, okay.
applicant.
All right, I will bring him forward for when you guys get there then.
Okay.
Great, thank you.
Thank you, Mr. Chair.
All right, let me say good evening and call to order the City of Annapolis Board of Appeals regular virtual meeting for July 7th, 2020. This meeting is being broadcast on the City of Annapolis YouTube channel, which you can find at the top of the agenda for tonight's meeting. My name is Bob Gallagher. I chair the board. In accordance with the city policy during the pandemic emergency, this virtual meeting allows the public to observe the meeting through the video link. The public also has the opportunity to submit written testimony for the meeting through an online submittal process available on the City of Annapolis website Forum Center. You can find that link also on the agenda. We'll begin the meeting with the roll call. So if our recorder, Tammy Hook, would call the roll, I'd be grateful.
Mr. Gallagher,
Yes.
Dr. Chin,
Yes.
Mr. Zazali,
Here.
Mr. Walsh,
Here.
Mr. Burnett,
Here.
Mr. Dews. Done.
Great, thank you very much. Before we do have a quorum, before we take up the agenda, a couple of more notes about the virtual format. The people that you can see on our screen are the members of the Board of Appeals. When a case is called, the applicant's representative and representatives of the city responsible for that case will also appear on the screen. Also participating in the meeting by audio only are our recording secretary, Tammy Hook, Julian Jacques from the city, who manages the technical aspects of broadcasting the meeting. Also participating by audio, we have our new counsel to the board, Cheryl Woods. Welcome, Cheryl.
Thank you very much.
Joel Braithwaite, Assistant City Attorney and Counsel to the Department of Planning and Zoning. Jackie Rouse with the Planning and Zoning Department and possibly other members of the Planning and Zoning staff. We ask everyone but members of the board to mute themselves except when they're speaking. If you wish to speak during the meeting, please raise your hand and unmute yourself and I will call on you to speak. As mentioned earlier, written public testimony is accepted via the online Forum Center on the city's website. Any testimony submitted in this case up until noon today will be submitted to the members of the board, the staff, and the applicant and made part of the record. Have the members of the board had a chance to review the agenda?
Yes.
I'd like to suggest one amendment and one correction. I'd like to add to the business that we have in front of us tonight, the review of the draft opinion and variance 2020-001. See if we're ready to sign that. And also, I pointed out to Ms. Rouse, there's an error at the very bottom of the agenda. The date of the next public hearing will be August 4th rather than September 1st. So our first substantive item on the agenda is adoption of the minutes. Do I have a motion to approve the agenda as corrected and amended?
I so move.
Second,
Second.
all in favor?
Aye.
Aye.
That's approved. So we have the minutes of the virtual meeting of June 2nd, 2020. Are there any conditions or suggestions for corrections to the minutes? Do I have a motion to approve the minutes?
So move.
And a second?
Second.
All in favor?
Aye.
Aye.
They're approved.
Mr. Chairman, may I just,
All right, now we come to,
if I could, I just wanted to mention
Yeah,
that
sure.
that I was not present at the June 2nd hearing, but I have since reviewed the video and of course had the documents, reviewed those as well for this project, and that were the subject of those minutes.
all right, then consistent with the board rules, the chair is satisfied that Mr. Walsh has reviewed the tapes of the earlier session. In this case, we're about to call special exception 2020-002, and he will be permitted to participate in deliberations and vote. Let's see, let's bring in the applicant and staff to the visual part of the meeting if we can. Julian, please. Okay, would the folks representing the applicant please introduce yourselves again?
Good evening, Mr. Chairman, members of the board. Phil Dales representing the applicant for the 110 compromise special exception. And also got Leo Wilson and Marshall Harris here.
Great. And who's involved for the city? Is that Ms. Rouse?
Jackie, you're muted again.
I'm representing the Department of Planning and Zoning in this case.
Great. Thank you. Ms. Rouse, have we received any public comments in the interval since the last hearing?
We have received no comments from the public since the last hearing, so there's no new information to present.
All right, well, then we'll get on with deliberations. First, I'd ask if there are any members of the board who have any questions they need to ask staff or the applicants before we actually begin our deliberations.
Christian here. On the list of attachments on the e-Tracket, I can't open Alderman Tierney's comments. That's the only one that seems to be a bad link. Like if anybody else has that.
If you give me, I know her comments were in support of the application, but I will have to, in order for me to get into track it, I'm going to have to go into my workspace. So it will take me a few minutes to get to that.
I just wanted to point that out before the record's closed one way or the other, that there's a dead link. And I don't know if it's because it's an HTML file versus a PDF.
It could be.
Okay.
I have a question too. Is this the application for 110 Compromise Street?
Yes.
Okay, and so is this the application that you and Dr. Chen recused from?
No,
No,
Oh, okay, different. Okay, all right, thank you.
that was,
Tyler. Or-
Okay,
Yeah.
thank you for the clarification. I just want to make sure.
okay. So Christian, as the senior among us, you have the privilege of starting off the discussions if you'd like.
Well, I think I'm short on discussion and really short on comment. I mean, I've read reminded myself of where we were last week. The police have no comments. The facility, the building is crying out for some use. I am heartened by the additional need to reinforce the pedestrian right of way on the water side of the restaurant. I don't know if we made that a condition or just acknowledged that it's a right of way and that some extra effort would be made to encourage public access along the restaurant side and not to create the illusion that it's private property on the back there.
I think Leo agreed to put up a sign.
Yeah. Good.
Yeah.
I believe you, I'm sorry, I believe you need to close the public hearing before you do your deliberations.
All right. The public hearing is closed. Now we'll continue.
There you go.
Is that correct, Leo?
Well, I'm not sure I agree to put up a sign, but I can tell you this, the way it's configured in the drawings and with everything else in the agreements that were part of the zoning text amendment, there's language in place that prohibits the applicant or the owner from blocking that right away as part of the agreements for the use of the building, and also the walkway space between Compromise and the creek.
I mean, it seems, I'm not questioning the floor plan A101.1, and there is specific notation that the pedestrian walkway will remain open to the public at times for et cetera, except special approval, whatever, okay. So we don't know how often they're gonna exercise that right. But it is well documented on the documents, so we'll let it go at that.
But no, I share your concern, Christian, that if we approve the application as it is, they're allowed to put tables along that walkway,
No, they're not.
along the outside wall.
That's not the case with that one.
Yes.
I refer to the floor plan A1.1.a.
Yeah,
It's noted, it's clear, it's scalable, there's a property line. I think it's safe. City code is documented on how they would have to, what procedures they'd have to follow to put something on that. The same as any other restaurant, if they want to have a special event or a party or something, the city does have a way to go that way. So it's all fine. And Leo, help me out. That where those two operable glass doors are, when they're open, does a rail remain in place, or is it open at grade to the dock?
No, the windowsill for that particular opening is up above the floor level in the restaurant. You may recall the restaurant sits about 2 feet above the walkway.
All right. Yeah, then I don't see this as an issue. I initially, my fear was that when those doors were open, if it was at grade, it would just spill into like a Pusser's. It would be an unpassable condition there, but I don't think that condition exists here. I think the application is complete. It's ready to go. It's a use that's permitted with this special exception. There are no comments from the city. I mean, from the other than in support. I will hold off on my motion until other board members have a chance to weigh in.
Well, I'd like to run that to ground on tables on the walkway along the Donner parking lot.
Chairman Gallagher, if I may,
Yeah,
there was
go ahead.
I think last meeting we had a discussion of tables in the pedestrian walkway from the lot to the water's edge. And I don't want that issue to be conflated with what I think Mr. Zali was raising regarding the space along Ego Alley, where the plans do clearly show no tables, and the statement recognizes that would be open for public to move along the water. In the last meeting, we had talked about the right of the applicant to place tables in that easement from the lot to the water, and we
From
proposed,
Compromise to the water,
that's right. Well,
along
yes.
the Donner lot.
Yeah, through the edge of the Donner lot. And my proposal at the time was that the condition be that tables only be placed in accordance with the plans we submitted, which do include some tables in that easement, if we are able to obtain the necessary permits to place those there from the city. So those could be a condition of approval.
Well, what about a sign that makes clear to anyone who's intimidated by people sitting in the walkway that it is a public thoroughfare to the water?
I think that the applicant would be amenable to a sign saying that we need to maintain at minimum 5 foot clear from Compromise to the water, even when there's tables there.
That would satisfy me. I'm
Yeah.
sorry.
I mean, the only reason this is a point of some historical discussion is that there is already a mandate that you must maintain 5 foot of clear on a public sidewalk to any sandwich board, sign, park bench, meter, anything. And it is probably the most ignored ordinance on Main Street. And I'm not going to make it my life's mission to fix that, but I don't want to make it any worse.
yeah. I agree with that, Christian.
If
Um,
you refer, refer to sheet A1.1B, there's actually a note on the plan that says that the pedestrian walkway along the water is to remain open to the public at all times through the duration of the special exception approval. So there, it's noted on the plans that you're approving, but
Ms. Rouse, I think that refers to the public access along Ego Alley, where they're also talking about the access from Compromise to Ego Alley.
Right, the side yard.
So
you
the side yard, I understand that there may be a legal requirement to have a 5-foot clear space through there. But timid people like me, when they see tables set up along that walkway, and servers standing in the 5-foot space serving the tables, they're going to think that's private property. I can't go down there. And I want to make sure that they're advised that's not the case and they can walk down there if they want to.
Mr. Chairman,
So,
Burning,
if
ask
Phil, if you're willing to go with that. Yep, go ahead.
I agree with you, Mr. Chairman, that, and I would like to see the sign there. I think if nothing else, the last couple of weeks, among the many issues that have been kind of moving your way around town is the question of waterfront access and the question of where there is public access and there isn't. So I think I would feel more comfortable making sure that it's definitive with this project. And I think the sign would be sufficient for that.
So if it's okay for me.
Mr. Chairman,
I'm sorry, Ms. Shannon.
Leo was first, but raise your hand next time, Leo.
Sorry.
Or we'll smack it with a ruler.
Why don't I let Ms. Chambers go first?
Okay.
thank you, Leo. Mr. Chairman, I agree with both you and Mr. Walsh about a sign, and because I do believe it is a slippery slope. The image that pedestrians will perceive will be that it is not public. So I would like to make a suggestion as to the sign. So take it one step further, making it a requirement that the sign be very clear that it is a walkway that is open to the public, and maybe even having a walking figure on it so that from a distance, a pedestrian can clearly see they can walk from Compromise to Ego Alley past the dining tables.
Nadine, would you be comfortable leaving approval of the sign to the discretion of planning and zoning?
Not really. I would really like a very clear sign.
Do you want to be the person, or do you want to design one to attach as a condition?
Sure. No, I'm just joking. Yes, Jackie.
well, I just wanted to point out that, I think that we would ask, I think if you set parameters for what you want the sign to say, we would ask the applicant to design the sign, because HPC will have to approve that sign. It will have to go to them for approval. So
Jackie, we don't, this is not we're not HPC, we're not graphic designers, we're not a lot.
Right.
There's a lot, the list of things we're not is long and wide.
Really?
What we would like is the city ordinance to be communicated in such a way
Clearly.
that the lay public understands that they have the right to go through there. Hi, Leo.
That's what I meant by parameters, and I think we ought to.
The parameters are in the code. The parameters are there, right? Share the
Mr.
road.
Wilson has a very unique answer to this question. Yes,
Is he
Leo?
commenting on the side?
So I've been communicating with the owners of the property as the discussion has been ongoing. And in light of the concerns everyone has about access to the water, given current events, he's amenable to putting up a sign on the building up by Compromise that would say public access to Ego Alley, or whatever we want to say, to City Dock. And that way people would know that it's public access along that way to get down to the waterfront. And that would eliminate questions about it. So we're happy to go ahead and work with planning and zoning staff and design a sign that would do that. And if there's something else, I'm happy to talk about that.
Nadine?
Leo, I think it would be helpful to have signs in both directions.
Fine. Yeah, and that's what the applicant was saying to me as well. So we can do signs at each end that says public access to Compromise Street and public access to the waterfront. And that way it will be clear to everyone that that's open. And the only time some of that can be compromised along the waterfront, just to go back to that for a minute, is during the boat show. That becomes kind of part of the boat show realm, I guess I would say. So it is blocked from public access at that time. But other than boat show, we don't anticipate, and there's no reason or no even tool for us to block that off.
Well, Leo, maybe you can be awarded some graphic contract to unify the city's waterfront access language and imagery, so that at a distance, citizens can recognize public waterfront right access points.
Well, I mean, in all seriousness, though, I think Sally Nash had worked on a sign package for waypoints down through that
We have
area.
wayfinding signage.
Yeah, so maybe I could just talk with Sally about what the graphics on that look like and tie it into that package. It should be pretty straightforward, but I know we've talked about that before, all the way from the bridge down to downtown about these wayfinders. So maybe there's a way to tie it into that, but
Chairman Gallagher?
Yeah.
Presumably, there'd be a motion of some kind to include a condition related to this sign that some of the board members would like to see. My one request would be, as you make the motion and then eventually write the opinion with that condition, that it be not so prescriptive that it forces us into a position that might be problematic with HPC. So the more generalized, but with still achieving your point, that would be our request.
Yeah.
Well, I believe that if we use, the same those types of signage that were approved as part of the wayfinding program, that should not be problematic, because I believe that there are signs in the downtown area approved by HPC out of the scope of that whole wayfinding design program. So that is probably an excellent way to sort of get to move forward with it. And maybe that could be part of the condition, Bob, that becomes part of the wayfinding.
I don't think we should be so prescriptive that we're actually giving architectural and graphic conditions, right? That's for the next phase of design development and improvement.
I guess by making it part of the wayfinding signage, you are tying it to a program that we're using citywide in terms of having public identity as to what's where in terms of.
Just, I think what might be a nice hybrid of those two proposals is if, as a suggestion, that the language in any condition refers to that program as an example rather than as a requirement, to say the sign would achieve certain things similar to the sign package, the wayfinding package you're referencing, so that gives some flexibility in case we need it with HPC.
We will take a cue from our much beloved comprehensive plan. It'll be consistent with.
There you go.
Consistent with.
Yeah.
I think we've beaten this to death.
Yeah. Okay.
We'll put it at both ends.
Andrew, any comments from you as our second most senior member here?
Nothing that wouldn't be sarcastic and non-productive. So I shall. No, I mean,
that in itself,
everything's been pretty straightforward. I think we've talked about it. That was the only concern that I had as well, was making sure that public access was clearly delineated to the waterfront area. But other than that, I thought all the plans were detailed and we addressed most of the issues. The only thing that I can't remember where we left off, and someone can just help remind me of, there was discussion last time about where the stage for the live music was going to be, and my notes in recollection are slightly incomplete on it being moved, and I don't know if we ever.
It was moved. One of the drawings showed it on close to the exterior perimeter and the overhead doors, and then it was clarified in a later drawing that it's an interior.
Yeah, I think at least at the time we all felt, I don't want to put words in your brain, but I think we were satisfied at the time.
That's what I thought.
And this has come up in many other special exceptions, that the noise ordinance is really not our purview. It's covered very thoroughly in the city's ordinance, and we can't undo what is already in city law with regard to decibels and property line and all that other stuff. they're compelled to follow that rule. They can put their stage wherever they want, but they
Well-
have to follow the rules, the sound laws.
Well, just to
We
speak.
have actually required in other applications that stages be put in certain specific locations. And, you know, that you still have to follow the noise ordinance, but we have also required people to identify where they're putting their stage and
I'm not sure we ever moved.
so we
the
did
stage.
require.
We may have, but
required.
As a refresher for the board, if it might be helpful, I think the location of the second floor stage, which is near to the stairwell and kitchen, was far enough away from any perimeter that it was acceptable. And then the original location of the stage on the first floor was closer to the edge of the building that was, you know, facing Ego Alley and Market Space, but then was moved away from that edge to be a little bit more interior to the building.
Right,
Do we
and
know
that's-
what seat that's on?
You can see that on EA 1.1A. The correct location is interior from that outside wall. It shows
Right,
on-
that's what I thought. Okay.
So that's the location that's proposed.
Okay.
That's all I had, Mr. Chair.
Thank you, Andrew. Nadine?
I believe, Mr. Chair, that last meeting, we also discussed in terms of noise, because there are these window door-like structures that can be open, that perhaps we might comment on how many of those doors could be open while there is live music, so that it doesn't make it an outdoor music performance. I only because we discussed it last time, I think perhaps
Well, I think
having not all of the doors open at the same time, some kind of restriction.
it isn't the way you would measure how many doors can be open, whether the number of doors you had open results in a violation of the noise standard.
Okay.
Yeah, I mean, that would be my concern, to say, okay, you can have 2 doors and not 4, or 3 doors and not whatever the case may be. I think we would, without having any information or data to support it, it would be sort of an arbitrary number. So I don't know how, I mean, I agree. And I share, that's why I brought up the stage issue itself. Was the discussion was revolving around the noise issue, but I don't know how we would pick a number without it just being arbitrary.
Anything else, Nadine?
No.
Rob, do you have any questions? Rob Dews, you want to unmute yourself and chime in if you have anything to say?
He just muted himself, Bob.
Yep. Push
All
that
right.
button again.
You hear me now? Okay.
Yes.
No, Chair, I don't have any additional questions.
All right. Thanks very much. I have one idea that I would just throw out there and see what kind of interest there is. And I don't know whether we actually can do it, but I mean, one of the issues that comes up for us over and over again is the failure of someone who has received a special exception or a variance to comply with some of the conditions. So the one that keeps coming up over and over again is the plastic utensils. And I know our applicants here have promised they're not going to do that. But I assume the earlier applicants in the problematic case did as well. And the same thing could happen surrounding the access along the boardwalk, along the Donner lot. And even with noise, people complain that if you go to the police, nothing happens. You complain to planning and zoning about the utensils, nothing happens. And I credit that. I understand there might be reasons for it, but what would you think about if we added a sentence at the end of our order granting approval that says that the board retains jurisdiction to consider complaints about whether the applicant has complied with conditions and whether the special exception should be withdrawn.
Mr. Chairman,
Yeah,
I would think that'll likely be problematic, and I'll defer to the city attorney in the Office of Law on this one. I think that might be problematic with regard to the board's authorization under the state code. However, I think my understanding of this issue of enforcement and compliance is that if a condition of the approval requires that all applicable laws of the city be followed, then a regular zoning complaint would result in a citation and then eventually a revocation of a certificate of use in accordance with the special exception. And so really it's a matter of making the existing process work properly, and that if there is a complaint and there is an enforcement action to a certain number of times, that then there are harsh enough penalties so that all conditions and other rules that are outside of the special exception conditions by reference are followed.
Yeah, I think it's just a question of due process, right? We don't have a complaint, somebody doesn't like Phillips crabs, they complain about noise, right? I don't think that's a slippery slope. I don't think we're prepared to.
And I would also defer to our counsel on this, but I would imagine we don't have the authority to put something in there with that specific of language, but I think that we could make a condition of the application, as Mr. Dales has suggested, that they comply with all applicable rules, regulations, zoning laws, etc. And then there would be a process. It wouldn't be a process for us to take up, but that would be a mechanism to go down the ordinary course of how a complaint would be enforced and could potentially result in revocation. But I don't think it's something that we would be able to retain jurisdiction over, but that's why we have counsel to the board.
there is a process now, and we have evidence that it doesn't work.
Well, we know it doesn't work in at least one case.
Well, we've heard the complaint more than once in the noise context. That's a little different because the police are in charge instead of the planning and zoning folks. But anyway, any other thoughts on that? I'm not hearing a groundswell of support.
This
What-
is
what-
Joel Braithwaite from the office.
Yeah, Joel, please.
Okay, so basically, the infractions that you talk about are subject to due process and notification and other things, and a lot to allow individuals to defend themselves against allegations, because everything's an allegation until a finder of fact determines that they had in fact violated as they were accused, and that's our civil infraction, civil enforcement process. We are a complaint-driven jurisdiction, such that if complaints arise, because we wouldn't know, we're not actively policing, but if complaints arise and we investigate and we determine that something happened, we can in fact follow up with the appropriate civil citation, and the people will be able to have the opportunity to set forth their facts, and then the accuser set forth, and even if the accuser is the city, set forth their facts, and the trier of fact, the decider, decides what in fact happened. And that's the process once something leaves the board. And I think that consistent with the opinions you heard today, there would be issues with retaining jurisdiction where the specific jurisdiction of the Board of Appeals is written, and in every sentence it has import. And if that's not something that can be freely interpreted as part of any of the current sentences which define your jurisdiction, then you wouldn't be able to retain jurisdiction over the discussion.
And just, Mr. Chair, consistent with what Mr. Braithwaite has just said, what might give the chair comfort is that if there were a finding of an infraction and there an enforcement action brought on the applicant, then the applicant might appeal that decision from the Department of Planning and Zoning Director, which would bring you jurisdiction back. You wouldn't have retained it, but you would get it back, on that particular complaint, because that jurisdiction's already been created for you by the state code.
Yeah, but it's not according to your analysis, it's not there unless planning and zoning does something. And we understand that the complaint about the plastic utensils has been made and nothing has been done.
Well, Mr. Chair, my response to that and I'm hesitant to say this, but those who have had decisions from the Director of Planning and Zoning that no citation has been made may file an appeal, and if they have standing and all the other requirements to bring that appeal to you, they might bring that back to your jurisdiction in the same way that an applicant subject to the citation would.
Well, let's give our new counsel for the board a chance if she has anything to offer. Ms. Woods?
Sure. I would say that I have to agree that due process, if there's a complaint, it would have to be subject to due process. And there wouldn't be a way for this board to withdraw its approval of the special exception without that due process having taken place. And it sounds like the problem is the enforcement, from what I'm hearing, is not happening. And so I know that Mr. Braithwaite just said that they're the finder of fact. I don't know if there's a hearing officer. I don't know if there's a enforcement body that looks at these sorts of complaints, but that seems to be where the problem is. But I don't think that we can necessarily put it in as a condition that the special exception would be withdrawn, because the complaint could be frivolous. The example you're thinking of, it sounds like it's not frivolous, but there could be other complaints that are frivolous. And so the enforcement needs to happen. And I think that's the problem.
Cheryl, I wasn't thinking that there'd be an automatic canceling. This board affords due process at every hearing, and there's no reason why we couldn't have a due process hearing before we decided that the condition hadn't been complied with and the special exemption was withdrawn.
But I think the issue is that once we approve it and it goes forward and it's built and it's done, and now there's an enforcement issue, we don't have jurisdiction over it anymore.
Yeah, that's a question. That's a question. And I'm not sure what the answer to that is. And
I would venture to say, and I don't, in theory, I think it's a good idea, but I think the problem lies elsewhere, and it's not for us to try to fix with some language that potentially causes chaos for everyone down the line in all sorts of issues, when it seems that the enforcement issue is something that should be addressed by someone other than this board.
I would suggest that this idea has escaped the corral, and maybe we could have a second look at this in a different forum, Bob, if we could.
yeah, that's fine.
Okay.
That's fine. Any further discussion on the application? Okay, I think we're looking for a motion that would approve the application with the added condition about the.
I will take a crack at it.
Thanks.
Motion to approve the special exception request number SE 2020-02 for the reasons stated in the staff report provided into evidence, the plans, the testimony, the staff reports from the various appropriate agencies, and the lack of public comments against, with the condition that in addition to the drawings, a signage package be added, which communicates and is consistent with the wayfinding plan that emphasizes public right-of-way to and from City Dock and Ego Alley / City Dock and what is the street? Compromise? No.
Compromise.
Compromise Street.
Second.
All right, all in favor?
Aye.
Aye.
Congratulations, Mr. Dales, Leo, Marshall. You've got a special exception.
Thank you very much, Mr. Chairman. Members Wall,
Thank you all, members of the board and staff, Jacques, for making this happen.
And
And
Bob, what I would suggest that we could do, you and I, or some other people on the board, whoever, is I initiated that. You guys don't have to hang around if you don't want to over there, Phil and Leo. Is we could find out what what starts an investigation or a complaint, right? Like I wrote an email to Sally. Is that a complaint? Does that get recorded as an official complaint, or is that just an email, right? Like, if it didn't happen, if due process involves a complaint looks like something and it counts as strike one when it meets these requirements, that kind of thing. You know.
Yeah, Joelle, you were so diligent going back to the APF stuff. If you have any inclination to look at this and get back to us, we'd be grateful.
No, absolutely. Cheryl and I will caucus, and we're going to caucus with Mike Lyles, the city attorney, also, and that way we might be able to come back with a good explanation of what the authority is.
Great.
We shouldn't
Okay,
be
we have
known as the
one-
board that's easier to get a special exception than file a complaint.
Let me just say that I feel that the department has a pretty good response rate, even on emails that people send us about asking questions about, how is it that so-and-so can do such and such? I don't know what the email was that you sent to Christian, that you sent to Sally, but did you not get a response to that?
I don't think, I would like to retract the to Sally part, to Sally's department. I don't know. I don't remember who I actually sent it to.
Okay,
I might have sent it to Gary, actually, asking,
okay.
is it possible that they're, I said something like, they're using plastic cutlery in direct violation to the requirements of the special exception. And he said, they are? And I said, yes, I've seen it now 3 times. And it's probably my fault for not following up, because Gary and I then talked about it in chamber, and I don't know, whatever, he acknowledged it and it kind of circulated as discussion, but I don't know whatever became of it.
Okay, well, so the process is that we have a zoning enforcement officer in the office.
We do?
If we get a complaint, yes, we do. Her name is Lisa Minker, and if we get a complaint about somebody's doing such and such, in most cases, it is referred to Lisa to investigate. That is our process, and then Lisa's fairly diligent about investigating and notifying the person
that's to that.
who submitted the complaint as to what happened with it. But she is pretty diligent about following up on any
Right.
complaints.
And I
If you send something to Gary, that would, it maybe.
That would constitute not an official complaint in my book, right?
It has to be, somebody has to.
Somebody has to know, right? I get it.
Yes.
And I
we
guess,
do-
this is probably not the appropriate time, and there's other bigger fish to fry, so to speak. And the governor's emergency order allowed
Right.
takeout, and you can't be
So
sure
I
to
think
bring
there
my
are probably-
dishes back when you.
Yes. Right now, there are probably a lot of things going on with, especially, not just with food service businesses,
Right.
but with many businesses right now that are not really in accordance with
Right. I
what
understand.
they were approved
yeah.
for. So it's really not the best time.
I think we're trying to imagine a normal world where the normal order of business is followed, and we acknowledge that that is not right now.
Okay.
Okay, we have one more item before we adjourn.
Thank you, Greg.
Christian, the case variance 2020-001 that you so generously chaired when Nadine and I recused ourselves. There's a draft opinion there. Is that, you want to see if that's satisfactory to you and to the others?
Is it something I can do right now? I have to go. Is it an e-track? Where is it? Somehow I missed it, Bob. I
It
apologize.
was emailed to you.
It was? Who sent it? You, Jackie?
Yeah, it was an email. Ben Henry sent it to us and I forwarded it to everyone, and
Well, we can do
I
this.
think
by
I have
email
it
then.
here.
Christian
Sorry,
has
I
had a
got it.
chance to look
Information.
at it.
No, that's Mr. Rogers.
Yeah, if you haven't looked at it, Christian, let's do it by email.
Okay, yeah, fine. I can approve we can remedy that by email. Yep, agreed.
Okay, well then, please, if everyone would please review that who participated in the hearing and email me their approvals or if you have revisions or edits for it, please send those to me and then I will resend it to everyone with those edits if there are any. Is
Right.
that satisfactory, Christian?
That's great.
100% satisfactory.
So then, before you adjourn, Bob, can we just do a schedule preview for the next meetings?
Okay, lead the way.
Sorry, interrupt. What was the application number on that one, Jackie? 2020?
Variance 2020-01.
I will resend the email to you. I have to find it.
That's not necessary. I have it here.
That's
Okay. There were a lot of email. You've probably gotten a lot of emails in the last week or so because you got the hearing emails, and I think it came before the virtual Zoom.
It's the deck.
Yep, I got it here. Eco 701 Warren. Yep.
Yes, that's it. So here's our preview of the schedule to come. I sent you all an email today we have a meeting August 4th, and then we have a meeting on September 1st. And I wanted to make sure that we could have a quorum for, is it August 19th, Bob?
Yeah.
You know how dyslexic I am with dates.
Yeah.
So at the August 4th meeting, we have a very short, brief special exception application for a private school to locate at St. Paul's Church. You all have previously approved daycare centers there. It's the church at the corner of Farragut and Roe Boulevard, and it's like they have like 30 students. It's a very small, limited affair, and they're moving here from the Eastern Shore. And then we are going to hear preliminary matters on the appeal that was recently filed on the approval of the certificate of adequate public facilities for a project at 915 Chesapeake Avenue, and the approval of the mitigation plan that occurred with that. And the purpose of having the hearing on August 4th will just be to discuss preliminary matters related to that. There was also a opposition motion filed on that. Bob did a scheduling order on it that I think that was sent to them, and you all got a copy of that also, the scheduling order. So basically, then we would continue the hearing on that until August 19th, and that's when we would do the public hearing on that appeal.
Maybe not.
Or maybe not. That's a possibility.
We all know how complicated this case can be.
We could also continue it to September 1st.
That's more likely. So if you don't have something else you want to do on August 19th, we won't need it.
Okay, that's fine too. So what we're saying then tonight then is that you would be most comfortable with not having a meeting on August 19th and doing August 4th and continuing the appeal to September 1st. And
yeah, at the regular August hearing, when we go over scheduling in the case, I want to make sure we give them, all the parties, enough time to file the information that will be most helpful to the board in keeping the case on track when we actually go to the hearing.
Okay. We don't actually have to even announce what date we're continuing to. I was only suggesting that as a way that we wouldn't then have to re-advertise and repost if we just.
No, we'll do that because we need to give them that much notice to get prepared.
Okay. All right.
So do we have any sense of when we'll be back in chamber there?
Back in the, you mean live again?
Yeah.
I don't think it's going to be anytime soon.
All right, I'm not
not
disliking this format, but
Well, I think it's kind of hard to, considering what's going on a national basis now.
I don't
know that anybody.
I'm not asking you to make a prediction. I was just.
Right.
Yep.
I sometimes wonder if we're ever going to have a normal life again. So.
I mean, the one outcome of this, which I have no idea whether it's even permissible by our bylaws or city code, is the fact that we take public testimony as a matter of an open-ended thing, so that we're, you don't have to sit there till 11 o'clock at night hearing public testimony. We get it, we read it. I promise, I do read every email and every article. I get the sense of public opinion. But I don't know if there's a way that even when we were back live, if we have these large, well-attended cases, the public hearing portion is written only, right? Like submitted in a written format, and we don't actually have to open it up orally. I don't know if that's even permissible, but boy, what a way to streamline the process that would be.
Yeah.
Well,
A lot of people like to hear themselves talk.
right, but one advantage to this,
no
other
idea what you
advantage in terms of the public hearing aspect of this is if we have a public hearing and then we're continuing it to the next meeting, people who want to comment on the project wouldn't even have to watch the first hearing live. They could watch it the next day and then provide public comments. It actually provides a more flexible format in some ways.
Yeah, and as it stands, written submitted comments don't get any less weight or more weight than sitting in our chamber waiting 3 hours to give your opinion.
So this is Joel Braithwaite, Office of Law. I think that what you guys have an inherent authority as the Board of Appeals to convene your hearings in any way, manner in which you desire. So for example, as a body, think about there was, I'm going to speak factually, this is not political. There was an impeachment process in the United States whereby the chamber convening the hearing decided that no witnesses were going to be allowed. You guys have the infinite authority. You guys could say to your witnesses, I'm going to limit witnesses to 3 minutes, and witness, please give me something in writing, but then also tell me the 3 most important things you want me to know from, so there are ways that you could limit how the information comes or expand how the information comes. And that's within the authority of the Board of Appeals to decide on its own rules or its own prerogative, how each individual hearing, how will you observe due process and public testimony and other things in each individual context.
Thank you, Joel. That is very helpful. In the 10 years I've been here, we've always deferred or erred on the side of not limiting public testimony and not limiting witnesses and entering of evidence. It's only in the recent, I would say, 2.5 years where that liberal approach to things has really taken a turn to the verbose.
And again,
Bob, I don't know if
Speaking of verbose,
Accusing me of being verbose, Andrew.
no, not you specifically, but perhaps the topic in general.
Have you got a motion, Andrew?
You know, I always have the motion to adjourn.
Is there a second?
Second. The Memorial
All in
Andrew
favor?
Burnett.
Enjoy your staycations.
See ya.
Good night, guys.